Okay, greetings everyone and welcome to this first SciFac seminar of 2023. We are delighted to be having it on a very fascinating topic on the recent Constitutional Court case, finding that the common law can accommodate a defense, a type of an action, which we're going to discuss about a lot. And in this particular seminar, the action is called a SLAPP suit, which are often utilized by powerful and wealthy private actors to not to litigate in a good faith manner, but ultimately to silence criticism from activists and to use their power to essentially stop challenges to their behavior. And often defamation cases and others are utilized by people who are in those positions to intimidate, etc. And in some countries, there's actually a specific legal action and defense that you can bring to any claim saying that this is not done in good faith effectively. In South Africa, this came before the Constitutional Court, and as we will hear, the Constitutional Court, people are going to describe this in more detail, so I'm not trying to preempt, but ultimately utilize an existing common law defense to say that it sort of exists in the law. And we're going to kind of question whether that's adequate, the reasoning of the judgment, whether it actually helps civil society, whether the judgment's actually going to be able to enable people who faced with these kinds of actions to be able to resist those actions legally. And a range of other questions which our illustrious panel are going to engage. Just to mention to you, SciFac will also be having a seminar as part of the Human Rights Festival of Constitution Hill, and that will be on the 28th of March, and we're going to be discussing the jurisprudence and discussion around children's rights more generally, so that please diarize that in the evening at a similar time, and we will send further details on that. I also want to thank the Konrad Adenauer Stiftung for being co-partners with us in this seminar and for publicizing it, etc. And also I would like to thank those who helped organize it. It started off with Ropafatso Maposa and now Tandeka Koza, who's very ably put the seminar together. And I'm very grateful to her for her work on that, as well as Naomi Ho. So without further ado, we're going to jump into the discussion. And each of the panelists will have between 10 and 15 minutes to put forward a perspective on the case or to develop an idea related to the case. And then we're going to have a discussion, and we're going to invite those of you who are joining us to engage in a question and answer session, and perhaps some discussion if the panelists, if they have discussion or questions for each other, we hope to have some kind of lively discussion. We will end at a maximum in 90 minutes at 6:30 South African time. But we'll see how the discussion flows. So without further ado, I'm going to call on our first speaker, who is going to be Ms. Courtney Jones. Courtney has been a clerk at the Constitutional Court to Justice Majid, and she's currently a pupil at the Johannesburg Bar. Courtney, I don't know if you were involved with this case, but we're looking forward to your perspective, and over to you.
Thank you so much, Prof. Good evening, everyone, to all those attending the seminar, as well as my fellow panelists. Thank you so much to SciFac for the invitation to speak here this evening. It's such an exciting topic. As Professor Bullshitz mentioned, I was a law clerk in Justice Majid's chamber when this matter was argued and when the judgment was drafted and handed down, and it was his scribe. So it's definitely one of my favorite matters to come out of the Constitutional Court, although I'm obviously incredibly biased. My address will be very short and sweet. I will cover the following topics. So I'll briefly talk about what a SLAPP is, although Prof has already covered a bit of it. I'll just chat about the genesis of this particular case, as well as the principal submissions of the parties. I won't discuss CALs because I believe some of my panelists will probably cover that. Second, I'll talk about some of the two competing rights that were at odds with one another in this case, which were effectively the right to freedom of expression on the one hand, and the right to access to courts on the other. Third, I'll look at what the court held and whether the court sort of struck the appropriate balance between these two competing rights. Fourth, I will briefly talk about what SLAPPs look like in other jurisdictions. As Professor Bullshit said, other jurisdictions have enacted specific SLAPP legislation to deal with this sort of emerging trend of SLAPP suits. And then finally, I'll digress slightly and talk about the related but separate judgment that came out together with this judgment, and how these two judgments sort of interplay with one another, because I think it's really, really interesting, and it was quite a hot topic for debate amongst the judges. So by way of an introduction, as Professor Bullshit mentioned, a SLAPP suit is strategic litigation against public participation, and it has its origins in the United States of America and Canada. The hallmark of a SLAPP is its lack of merit, and it's brought for the sole purpose of discouraging a party from pursuing or vindicating its rights, and often not with the intention of necessarily winning the case, but simply to waste the resources of the other party in the hope that they will eventually abandon their defense. Having only originated in America in the 1980s, it's a very novel defense in South Africa, although Professor Marambo wrote an article where he said that SLAPPs are actually on the rise in South Africa. So it was only considered by the Constitutional Court for the very first time in the mineral sands judgment. So the origin of that case were three separate defamation suits that were brought by mineral sands, as well as some of their executives. They were then consolidated in the Cape Town High Court. The defendants in those suits, those defamation suits, were environmental lawyers and environmental activists, and the claims in those actions sort of collectively were in excess of 14 million rand. And if I'm not mistaken, I stand under correction, I think all of those were for damages, not for special damages. I think it was all general damages, and that will tie in to what I'm talking about later at the end of my address. So the mining companies are engaged in extensive sort of mineral sands projects in South Africa. I think they're in the Eastern Cape. It's the Tolman mine and the Kolobeni mine. And there's fierce community opposition to these mining activities. And the concerns relate to the alleged unlawful mining companies' operations, which has been said to be ravaging the environment. And in the course of this opposition, the activists are said to have made several defamatory comments against the mining companies and their executives. So the statements originate from a whole range of incidents. There was a series of lectures at the University of Cape Town that the environmental lawyers gave. There were several radio interviews that were also later published on the radio station's website. There were 2 ebooks that were published, as well as an interview on SABC's 50/50. So all of these activists were sort of sued separately, some together, one on his own, etc. And then, as I said, they were all consolidated. So in response to the defamation claim, these activists raised what they framed or called a SLAPP suit special plea. So they raised the special plea in their plea. And in response to that, the mining companies then raised an exception to that special plea on the basis that South Africa's common law does not sustain that kind of a defense. And the judge in the High Court, Judge Goliath, she dismissed the exception and found that South Africa's common law under the doctrine of abusive process does indeed accommodate that kind of a defense. And then the mining companies were dissatisfied with the outcome and then appealed directly to the Constitutional Court. So the Constitutional Court effectively had to determine whether our law accommodates a SLAPP suit defense under the common law abusive doctrine of abusive process, and if not, whether it ought to be developed. So the mining companies effectively, in one sentence, submitted that a SLAPP defense could not succeed where a case has merit. And the activists on the opposite end of the spectrum, also their submission in one sentence was that the merits of a matter are irrelevant and a SLAPP suit can be determined solely on ulterior motive. And that is the only relevant element in this test. So in contemplating these arguments, the court had to consider and balance these two competing rights, freedom of expression and the right to access to courts. And one of the questions is whether the court appropriately balanced these two rights against one another in developing this test. And so I'll very, very briefly go through these two rights because I think they're quite trite. So firstly, the right to freedom of expression. So the activists were arguing that a SLAPP suit, in this case, obviously in the form of a defamation, violates their right to freedom of expression, because it was brought for the sole purpose of silencing their criticism. And I mean, we all know the right to freedom of expression the importance of that right cannot be overstated. It holds an incredibly important place in our constitutional democracy. And without going into all of the case law that has wonderful quotes about the importance of a vibrant public participation within our constitutional democracy, it was actually very interesting within the other related judgment. There was a huge fight amongst the judges about the Constitutional Court placing the right to freedom of expression above other rights in the Bill of Rights. So on the one hand, the one sort of contextual pillar is this incredibly fundamental right, freedom of expression. And in this case, it is obviously intersectional with the right, with your environmental rights and environmental protections. And I think that's also why freedom of expression is so important, because it underpins so many other rights in the Bill of Rights, your political rights, environment, etc. So then on the other hand, you have the right to access to courts, which is no less important because it is utterly fundamental to the rule of law. So here you have the mining companies arguing that it would violate their right to access to court if they have a completely meritorious claim being dismissed for no reason other than the motive behind which it is brought. I.e., if a claim is justiciable, it should be heard, and to dismiss it without considering the merits would be a violation of a fundamental constitutional right. And again, the logic behind the right is that anyone can challenge the legality of any conduct. So as I said, an incredibly fundamental right. So you have these two very important rights at odds with one another. And the court now has to consider how to balance these rights and coming up with a test for what a SLAPP would look like. So the central question then was, because the way that the SLAPP special plea was pleaded by the activists was that ulterior motive alone was determinative. So the question was whether ulterior motive to the exclusion of the merits could be determinative of an abusive process, and that a claim can be dismissed on that purpose alone. And a debate amongst the judges was what a SLAPP in South Africa should look like, because it's legislated in other countries and here it's being dealt with under the common law that's going to be determined and defined by the court. What should it look like? Should it follow what it looks like in the USA, Canada, Australia? Why should South Africa have a SLAPP that looks exactly the same? But also put differently, is a SLAPP as defined by the activists, is that sustainable how they pleaded it? So the court considered that an abusive process can take various forms and there's no one defining central feature, and it's effectively a fact-like. And this was quite difficult about some of the case law that each party relied on in their submissions, because some parties were relying on case law that was relevant to vexatious litigation, where obviously you need several cases instituted in order to kind of hit that threshold. And then there was other case law where it was about, for example, malicious prosecution, where in that instance, the merits are irrelevant and it's only motive that's being considered. So because something like an abusive process is so fact specific, the case law was not of great assistance to the court in sort of determining and defining the scope of this defense. So the court said that where a plaintiff institutes litigation with no prospect of establishing a case, this would constitute abusive litigation. And it would be inherently difficult to establish, but where it's used for the sole purpose of abusing another party, it wouldn't even engage your right to access to courts. So the court held that merits and motive are both relevant in a SLAPP suit defense. And interestingly, they also define one another, right? Because a lack of merit would inform an ulterior motive. It would be much more difficult to prove an ulterior motive where there's a completely meritorious claim, for example. So the two elements actually can't really be divorced from one another. So the court obviously found that these two elements are both relevant. And interestingly, the parties kind of conceded that during oral argument as well. But at the end, the court left a strong nudge to Parliament to enact SLAPP legislation, because this is such a nuanced and technical defense. And there was even a consideration as to whether the court should sort of dismiss this application and just leave it to Parliament to fix. But of course, the court wanted to do something. But it's a very difficult position to be in. So the court didn't determine in this case whether this was abusive litigation or whether this constituted a SLAPP. The matter is now again before the High Court, and now it's up to the activists to prove their case within the test established by the Constitutional Court that this is in fact a SLAPP defense. So briefly looking at other countries, as I mentioned, 28 states in the US, as well as the federal US law, accommodate SLAPP. There's also SLAPP legislation in Australia and Canada. And I'll very briefly mention that in those states and in those countries, it's dealt with by legislation. And the idea is that there's a preliminary and speedy and inexpensive method of striking the cause of action out before the leading of evidence. So in California, I think this even happens at a pre-discovery stage. And the legislation establishes an onus and who must start. So effectively, it's for the defendant to allege that it is a SLAPP, and then the onus shifts onto the plaintiff to effectively prove some prospects of success in the main defamation or whatever the sort of substance of the main matter is. And they've established what test needs to be met at that early stage, because these are usually in the form of actions where no evidence has been led. So this is the challenge with now what's been left by the Constitutional Court, because I think that the substance of the test is correct. I think it balances the rights appropriately and adequately safeguards against either right being unduly infringed. However, I think there are huge practical challenges coming out of this judgment in how the defense is going to be implemented and used practically going forward, because we don't know what the test is. We don't necessarily know at what stage it must be brought. This issue of the shifting of the burden and who must prove what, none of that has been answered. So I think that's the real challenge in this judgment. But as promised, I'll briefly talk about the other related judgment that came out with this one. So people might not know that there was a second special plea that was raised by the activists, and it had to do with general damages. And they effectively asked the court to alter or declare unconstitutional general damages claimed by what they refer to as a trading corporation, because they unduly limited the right to freedom of expression. And because general damages in a defamation are there as solatium for a defamed person to restore their dignity, the argument was effectively that while a company has no dignity, so there's nothing to assuage. And there, I won't go into it more because that could be the subject of a whole seminar on its own. But effectively what the court held is it said where there is a claim for general damages, the court has a discretion to remove general damages from the list of remedies available to a plaintiff where one, the plaintiff is a juristic entity, and where two, the speech forms part of a discussion on a topic in the public interest, something like the flouting of environmental regulations by a large corporation. So in that case, a lower court can remove general damages off the table of remedies. So I just think it's very interesting because where SLAPP is very difficult to prove inherently because of the requirements, I think that judgment, read with this judgment, provides kind of a second safety net in that in the event that you fail to prove that it's a SLAPP, then the trial will continue. But the court can then say, this is clearly speech in the public interest, and I'm removing general damages. And I think that also protects public participation because it will reduce the quantum that these big corporations can claim.
Fantastic, Courtney. Thank you so much. That laid out the actual case, the findings, the whole background incredibly well as how you view the kind of problems with the holding, as well as the kind of cognate case. If you could pop that cognate case into the chat for people who would not know about it, that would be fantastic, because again, we want to be informed and also be able to engage further with the reasoning. So thank you very much for your presentation. And you kind of laid some of the practical challenges. I think our next speaker is Sithuthukile Mkhize, who's an attorney of the High Court and the head of Civil and Political Justice Division at the Center for Applied Legal Studies at the University of Witwatersrand. I'm also happy to say Sithuthukile is a student in the LLM in Human Rights course, and I had the pleasure of supervising her in her dissertation. And I know Cal's also a party in the case. So Sithuthukile, over to you, and look forward to your perspective. Sithuthukile?
Thank you, Prof. Can you all hear me?
Yes. Can you put on your video?
I'm trying to do that. The
Okay.
Technology is just getting the best of me. Can you all see me now?
Not yet. There is. There we go. There we go. We can see you now. Fantastic.
Great. Thank you. Thank you so much. And yeah, thank you.
Sithuthukile, we lost you. Hello?
Can you hear me?
Now we can hear you.
Oh,
Okay.
I'm sorry. So I was just saying, thank you to Courtney. It's good that you went first, because I think you sort of gave us the bigger picture behind what happens in courts, or in the constitutional courts rather, because we got to understand the sort of the difficulties that the judges had in coming to the decision. So maybe I want to sort of start off by speaking about the ideas behind us taking on the matter as CALs, and then I'll also try and build up on what Courtney mentioned about the case, or the court rather, sort of trying to shift responsibility to Parliament. Maybe not shift responsibility, but sort of outlining the importance of the role of Parliament in all of this. I'll try and build up on that, and then I'll leave the nitty-gritties of our argument, or the finer details of our argument, for Lerato, who is counsel in the matter. I think she may do better justice to it than myself. So yeah, we intervened as amicus in the case, initially in the High Court and then as well in the Constitutional Court. In the High Court, we obviously we have two sort of programs at CALS that were of interest for this matter, and those are the Environmental Justice Program, which sort of works with a lot of communities that are affected by mining, and mining, in the mine affected areas, as well as sort of just activists in the environmental justice sphere as a whole. And then the civil and political justice program, which also sort of looks at and tries to sort of look at ways of protecting activists in general. And when I speak of activists, I'm speaking about, or I'm referring to
Okay, we're having some problems with the connection of Sithuthukile. Sithuthukile, I'm sorry to cut you off, but unfortunately, we're not able to hear you at the moment. So I think I'm going to go to Lerato. Lerato, I think Sithuthukile has actually gone off, so I think we're going to just go on, and then we'll come back to Sithuthukile if hopefully she's able to get back. Now, Lerato, great to have you join us. And Lerato is an advocate of Lerato Pasha, is the advocate of the High Court, specializing in constitutional and public law. And she was formerly an in-house counsel at the Center for Applied Legal Studies. And as you heard from Sithuthukile, Lerato, you were involved with this case and making the arguments in the case. So we look forward to hearing your perspective. So over to you, and we'll bring Sithuthukile in if she is able to get back. But you continue, and you have your 15 minutes will start now. Go ahead.
All right. Thank you, and hi to everybody. I want to greet my fellow panelists and thank SAFEC for inviting us to this important discussion before the Human Rights Festival. I will try and pick up where Sithu left off. I think what she was going to speak of was also part of an important part of the conversation, just to give context as to why CALS joined the case and when it actually joined the case, but hopefully she will return. I was counsel on the matter, as indicated. I argued the matter both at the High Court and at the Constitutional Court. So how CALS got involved initially was we wanted to intervene as amici because the SLAPP suit defense hadn't actually been raised at that time. So when we made our application to intervene in the matter, I think, some lights went on and people realized, oh my God, yes, this is an actual thing. And it would actually be very good for the activists if this was a defense that was officially recognized in South Africa. And I'll possibly deal with that, why that is an amazing thing to have as part of our law later. But then that's when CALS came on board. We admitted, of course, as amici, and there were so many other complications at the High Court level with the matter, including the exception being raised, which landed us in the Constitutional Court before we could even go to trial. That should be the next leg, as Courtney put it. Then CALS had to grapple with what then it was going to bring on the table and what it is that we wanted to achieve as CALS, because part of what CALS does is strategic litigation. And as Sithu also tried to explain, CALS also represents activists and communities. So the case for us wasn't just about developing the law, which was an important aspect, but it was also about having a judgment which was practical and useful, and that could be useful to our clients in the future and activists in general. So we really wanted to have something that made sense and that everybody could rely on. And I say that because, as the first speaker mentioned, there were some victories, giant leaps that were made by the court, but there were also limitations which we had hoped we would have not had as the Center for Applied Legal Studies at the time. So we really approached the court at the Constitutional Court level to say, we believe that SLAPP suits was distinguished from what we typically saw as South Africa as an abuse of court process. And we said that really for two reasons. We did not agree with the notion that SLAPP suits could be did identify or that ulterior motive could be determinative of whether a matter before court is entirely a SLAPP suit. We firmly believed, as you would see from jurisprudence, both from Canada and the USA, that merits play a very large role in determining whether a matter is a SLAPP suit. But we also did not agree with the fact that a SLAPP suit should be entirely only about the merits and that ulterior motive shouldn't play a role, because that did not make sense. That is one of the stumbling blocks you would have to actually interrogate before a court in order for them to have a better idea of whether the matter actually is entirely meritless and what the ultimate purpose of bringing the litigation forward is. And I say this because we've already discussed that SLAPP suits are an intimidation tactic. They're brought forward to silence the public, to silence them on issues that matters, but primarily that would be activists and NGOs who speak up against environmental issues, big projects, mining, land issues, and so forth and so on. And to bring civil suits against them for defamation is extremely problematic, especially where those suits run in the millions. And it is clear that the applicants have no intention of actually recovering those funds from those activists. So we thought it was fairly important for the court to not just cement that SLAPP suits are part of our law, but to actually help us in establishing how we go about determining them once we are before a court. So it was an important thing for CALS to come up with a criteria, not that we pulled it out of a hat. We were actually informed largely by foreign jurisprudence and as to how they determine SLAPP suits, although they have the benefit, of course, of legislation, which we do not have, as already has been indicated. So we knew as we approached the court that we are relying solely on the development of common law on this lake to sort of leave us in a position where we don't just agree that SLAPPs are part of our law, but we know what to do. For example, when we actually do go to trial, how does a court then at that point go about determining if it actually does have a SLAPP before it? I don't want to say the court entirely failed in that exercise, because you will see from the judgment that at least they made two important findings. The one is that merits are part of what must be considered. And the second is that ulterior motive also plays a role. So you cannot divorce the two investigations from in your special plea when you determine if the matter is indeed a SLAPP or not. Of course, they didn't go into the further details of how we go about doing that, including how the reverse onus would work. And this is one of the things we try to suggest as CALS. I actually want to see if I can find our head somewhere. I should have done this before this discussion in hindsight. But we actually did try to put to the court a suggestion of how Canada actually goes about viewing SLAPP suits. And in those suggestions, we set out a test of what would be ideal in both the South African context and what we have seen work in foreign jurisprudence. The court somewhat agreed with us, but they didn't want to formally adopt the test. And this could be for two reasons. Apart from the heated discussions which happened in chambers, which obviously we were not privy to, thanks to Courtney, now we have, we're like a little fly on the wall. But I believe one of the biggest challenges is how complex SLAPP suits are innately, and how much work has gone into investigating SLAPP suits and how to carefully craft them in the foreign jurisprudence, but also in our own South African context, where freedom of expression is such an important element of our law and the right to access to court, particularly because of our turbulent history in South Africa, where you would know that because of apartheid, certain things couldn't be said. So freedom of expression is an important right to us, but equally so the right to court. And because the court sort of crafted the judgment to give a balanced view, my sense is that they found a way to protect the right to court while also cementing the importance of the right to freedom of expression. And I say this because if you accept that merits have to be part of the test, and that merits have to be part of the inquiry before any court can decide, for example, if this is a meritless suit and deserves to be thrown out, then effectively you are having a form of your day in court. The inquiry will be done. I think at some point we need to engage with what do we really necessarily mean by protecting the right to have your day in court. That may not necessarily look the way you do want it to look. A procedural law, for example, has always been such that courts can regulate their own rules. And part of those regulations include things like introducing a bar if pleadings are not filed on time. We also have the Prescription Act, which has never been challenged for being unconstitutional in the sense that it limits your ability to go to court at a particular time, and therefore we say that that takes away your right, your Section 34 right. Even if we can accept that that is problematic, we must then apply Section 36 to see if that limitation is warranted, considering the nature of the limitation and the purpose. I think the court must have had this exercise to think about if we are to have SLAPP suits in our law, and if we are to consider them as a defense, why then would we want to exclude a person from being able to pursue the case? And the answer is in a way simple. And it's because if a matter is indeed a SLAPP suit, what you wouldn't want to do is have a position where activists, for example, or defendants are dragged through the entire process of litigation, which the entire aim, one, is to silence them, second, to frustrate them financially, and to just drag out the process for as humanly long as possible, abusing court processes, so that you can actually end up giving up on what it is, whatever it is you were trying to challenge or put out in the public. So if SLAPP suits were adopted into our law, yet you had to go through the entire trial and they were not treated as a special plea, it would defeat the purpose of having a SLAPP suit defense. And this is what the Canadians have done. And this is what CALS was suggesting the courts adopt as part of the test in order to truncate the proceedings so that you're not exhausted financially by the time you get to the point where it is actually interrogated whether there was an ulterior motive to the case to start with. So I want to believe that is some kind of a striking of balance, protecting the rights of activists to be able to speak out, and NGOs and the public at large to say so-and-so is doing something that we don't agree with, and it is in the public interest to speak about this issue. And I mentioned that as well because you will see from the pleadings that one of the things that defendants complained about is that the applicants never at any point alleged that the averments made or the allegations made by the activists were false. And yet here you are trying to come to court and telling people that you're going to sue them for making certain statements, yet you're not even alleging that what they're saying is a lie. I think that it was a very important milestone, not just for CALS, but for NGOs and activists and the public at large to say, people have a right to speak up against wrongful conduct, but also it is part of your duty as an active citizen to take a stand where you see wrong being done, and you don't just sit and say nothing and then you want to complain about it later. I think the court in that respect tried to find a very delicate balance. Again, my complaint would be that the test at this point is not really clear, but I take comfort in the fact that at the very least, we do know that you will have to test the merits and that you will have to consider ulterior purpose, but also that you can actually do that as a special plea. And I think that takes us at least 2-3 steps forward.
Great, thank you very much, Lerato. That's excellent, and I think raises this problem of how do you avoid going through a whole trial to test the merits, essentially, or application, and then actually defeats the purpose of the whole defense. Mm-hmm. So whilst at the same time having some sense of whether there is anything. And so I think one of the major holes that's coming from both presentations we've heard so far, it isn't clear how the procedure is going to work in some ways in relation to this defense, and when it's going to be allowed to take root and at what point, and how it's going to how it's going to operate. So I think we need to interrogate that a little bit more. I think I'm going to go Sithuthukile. I think you are back with us. I think I'm going to, because we are testing the limits of Charné's load shedding. I think I'm going to go to Charné just to allow her to have her voice heard, because we hope she's not going to get cut off, and we'll manage through the seminar. But in case not, we'd love to hear what your perspective. Charné is an attorney of the High Court, specializing in strategic litigation, and she's been involved in the environmental rights program of Lawyers for Human Rights. As a result, I mean, this case dealt with a lot of environmental issues. So in the actual fact, so we're looking forward to your perspective. Charné, over to you.
Thanks, Prof, and thanks for inviting me to speak on the panel today. Lawyers for Human Rights, we represented the Southern African Human Rights Defenders Network in their application as amici. I was the attorney on record. Ultimately, our client was submitting, their submissions were based on international law instruments, which were both binding and non-binding. And why this was particularly significant was because in the judgment, the court did thank us and said that our submissions were helpful to them in coming to their decision. So I'm just going to speak a bit to the submissions that were made on our part, insofar as they relate to the criteria that was established by the court in the assessment of the SLAPP defense. So our client was advocating for an order against attempts to suppress rights to public participation, the right to freedom of expression, the freedom to receive or impart information or ideas, and academic freedom. And like I said, our intervention was based on advocating for an order in accordance with international law trends in the realm of protecting human rights defenders. So when you look at the criteria that was established by the court, if you look at the consideration of the abuse of process, the vindication of rights, and the use of court processes for improper ends, it covers the public participation aspect and freedom of expression aspect of our submissions. So often in cases like these, like the other panelists have mentioned, litigants tend to bring SLAPP suits. The litigants that tend to bring these SLAPP suits are very well resourced, and they take advantage of the fact that the organizations or the activists against which they bring the matters against or not. So in our submissions, they were related to the protection of human rights advocates and their work. They pointed out the risk of intimidation and threats of violence that human rights defenders are often victim to in cases like these. And in our submissions, we also spoke about how SLAPP suits undermine the ability of civil society actors as a whole to exercise their rights to freedom of expression, of assembly, and of association. And our submissions emphasize this latter point, that the violation of the right to freedom of expression is characteristic of a SLAPP suit. And in relation to this, we did quote the UN Special Rapporteur on the rights to freedom of peaceful assembly and association. And she explains that SLAPP suits use all kinds of tactics to basically exhaust activists, exhaust them in terms of their resources, their capacity and their morale. And like this case, SLAPP suits include exorbitant claims for damages. And they make allegations which are designed to harass and overwhelm the activists against which the SLAPP suits are brought. In our submissions, we also described what a fertile environment for instituting a SLAPP suit looks like. And again, we quoted international instruments. In this regard, we spoke about the consideration of how expensive the legal costs are, the flexibility of laws in the country that target speech, and importantly, the absence of safeguards like anti-SLAPP statutes or discretionary cost awards against abuse of process. But on this point, personal cost orders are, personal cost orders are usually used to punish litigants for an abusive process. But in our submissions, we asserted that the court has to recognize that in cases like these, litigants are substantially wealthy, and so cost orders don't have much of an impact. So by its very nature then, the litigants who bring SLAPP suits use the court process for improper ends. And ultimately, our clients had hoped for a remedy that would not stifle the work of human rights defenders. And we envisioned an order of this nature as, we viewed it as one that would restrict how effectively human rights activists may promote adherence to the Constitution in general and to the Bill of Rights. So once the judgment was handed down, our client, the Southern African Human Rights Defenders Network, they were pleased and viewed this as a first step towards recognizing SLAPP as an abusive court process and how it poses a serious risk to human rights defenders and their work. The Southern African Human Rights Defenders Network, that's what their work is based on protecting human rights defenders. And from our view, we were welcoming of the judgment in that it does limit a corporation's ability to make claims for general damages. We feel it's a recognition that SLAPP suits like this one, they stifle critical voices by activists. They pressure people into silence. We are concerned about the discretion that's given to courts to exercise this limit. And I think what's important in this discussion and what's come through from all the panelists is the recognition that SLAPP suits, they deflect attention away from important conversations that activists are engaged in. Yeah, thank you.
Okay, thank you very much, Charné, for your perspective and for examining some of the work of Lawyers for Human Rights and the submissions to the court. Much appreciated. Sithuthukile, I hope we're going to have some success with having you come in and give you your chance to have your say. So I'm going to hand over back to you, and please go ahead and perhaps about. You're already a little bit into your presentation, so perhaps if you can do it in about 10 minutes, that would be great, so we can open the floor for some more discussion.
Thank you so much, Prof, and apologies. Technology is just not on my side today. I think, the background and the motivation why CALS sort of wanted to take this matter on has already been covered. I just want to make 2 points. I don't want to take long because I'm cognizant of my technology issues. So the first one being, what does this mean now for the outcome of the Constitutional Court? What does it mean for our clients and for activists in general? And has the court done enough to sort of protect activists from these lawsuits? So I think my perspective is that we have gotten somewhere. We previously, before this judgment, did not have any recognition of a SLAPP suit. I did see it problematic that it was sort of used, or it was defined as falling under the doctrine of common law. The doctrine of abuse of court process, the common law doctrine, because I think what we had always sort of advocated as CALS is that we wanted SLAPP suits to be as radical as it was. What is radical like that? We wanted SLAPP suits to be recognized as not under the abuse of court process doctrine, because we said that they were unique and they were complex, as the parties said in the litigation. It's a complex animal that needs, we thought, its own sort of recognition separately from the abuse of court process doctrine. And I think this also sort of speaks to what we're doing now as CALS. Post the judgment, I think we had initially said, yes, we will partake in the litigation because we want the common law to develop. But importantly, we want the legislature and Parliament to take steps to actually, to one, recognize the need for there to be legislation and sort of address this gap that we have in the law, but two, give us the details as they are supposed to in terms of the Constitution. Give us the finer details of what of a SLAPP suit is, firstly, but also what the test is, and sort of bring more clarity and much more to from what the court has already done. The courts did a lot, but I think my view, and perhaps our view, is that it could have done better. But maybe it did what it could, and it's now left to the legislature to sort of take it forward and do what it's supposed to do, so that there is better protection for the activists. I was saying what it means now. We have a law. It's all good. Well, not really a law, but we have development in the common law. It's all good. It sort of addresses that chilling effect that we said we wanted to address from when we intervened as amicus in the Reddell case. That chilling effect it has on freedom of expression. I think what we have now really does sort of go some way in addressing that chilling effect, because then we know that activists would not fear expressing themselves by way of speech or even by way of protest, because of the sort of the threat of strategic of the SLAPP suit. So yeah, I think I'll end it there and sort of say, from our part, we think that more still needs to be done, and we are at the stage where we want to try and lobby, not really lobby Parliament, but sort of try and develop some recommendations for Parliament to sort of consider in adopting legislation that deals with SLAPP suits, that recognizes SLAPP suits in South Africa. I'll leave it there. Thank you.
Thank you very much, Sithuthukile, for your presentation and your thoughts in that matter. I think that's a common theme here, that we need more detail and we need Parliament to step in. The problem is to get the attention of Parliament. So I think there's a question of, is there any, I don't know if anyone can answer that from the group, is there any appetite for a SLAPP defense? Is there any lobbying going on in relation to a SLAPP defense? Etc. And maybe some of the organizations could answer that. Lerato, I see your hand's gone up. Let me just say that those people, we're now going to have a discussion. Those people who would like to have a discussion, you're welcome to put up your hand and just orally ask a question, or you can drop it in the chat. So Lerato, I see your hand up. Please go ahead.
Okay. Thank you. I can't speak to the lobbying part. No, I'm not in a position to do that. But I thought, because I hadn't actually explained earlier what it is in terms of a test, that CALS was really trying to advocate for. And as I suppose, as radical as that may have been seen by others, but it really did make sense in line of like the foreign jurisprudence. So we had formulated, not from nowhere, the following test, and we had hoped that the court would be amenable to introducing something similar, so that we're not left to our own devices in the next hearings and trying to figure out where to go from there. But we had said the following: in the event that a plaintiff brings proceedings against the defendant, as had happened, and the defendant is of the view that the proceedings constitute a SLAPP, as what happened here, the defendant ought to be able to bring a preliminary defense, which is what we believe a SLAPP suit should be, because if it's not a preliminary defense, it defeats the purpose. For instance, we said it's perfect as a special plea, in terms of which the defendant would have to satisfy the court that the claim brought by the plaintiff arises from the defendant's conduct, expression that was committed in relation to a matter of public interest. We believe that's a hurdle that would be fairly easy to satisfy, especially in the facts of this matter, for activists, for NGOs alike, for people really acting in the public interest. And we thought this is a necessary element to distinguish SLAPP suits specifically from other forms of abuse of process, because this defense, if you would look at the foreign jurisprudence, is limited almost to public interest defense. It's not a defense you would raise perhaps on your own if you're fighting with a spouse and the spouse doesn't like what you said and they try and sue you and you then want to go to court and you call it a SLAPP suit, unless you would have to show that element of acting within the public interest. And our courts have had quite a few discussions of what we should view as actions in the public interest. So that was an important thing for us to come through from the test, so that, again, the defense itself is not abused. Then we also suggested that the plaintiff in turn, after you as a defendant has raised the defense of a SLAPP suit, would have to then satisfy the court that it has a prima facie case against you as a defendant. That's the first thing. The defendant does not have a bona fide defense, and that the interest of justice favor that the claim proceed to trial. Although you may have been acting in the public interest, that then becomes the reverse onus. You then have to show as the plaintiff that no, it's fine, we can see you acting in the public interest, but it is still in the interest of justice for this matter to be ventilated at trial. Obviously, what then the court would consider to be in the interest of justice inquiry is a very, very broad spectrum. So we didn't suggest to the court what they would have to take in mind, but we firmly believe that our own jurisprudence would have been offering proper guidance as to what the court would have to go and look into in deciding whether it really at the end of the day would be in the interest of justice or to proceed to trial, given the fact that the matter potentially is a SLAPP suit. Obviously, the merits would play an important role in making that decision, although that would obviously be in the discretion of the court at the end of the day to decide if they agree that the matter must proceed to trial or not. But effectively, that is the test that we had hoped would somewhat filter through from these proceedings. I suppose it was some part of a victory, but not entirely giving enough guidance as we had hoped. That's what I wanted to add for now.
Thanks, Lerato. That's helpful to kind of think about alternative possibilities for the test, right, and how it should be described. One thing that I noticed, the test seems to be quite complex to establish. Certainly, if you have to establish it as an NGO or etc., it strikes me as quite inhibiting, and it's not that it's actually going to provide that much protection. So I'm concerned about that, I must say. Charné, I know, is going to have problems with her battery. She's notified us. So if anyone has a question for Charné, please ask that question. I see we have one hand up from Tina Bako. Tina Bako, you have the floor. Please ask your question.
Afternoon, sir. Thank you so much, everyone who presented. This was very interesting to listen to. I enjoyed the entire presentation. And my comment is based off like a very superficial reading of the case. I haven't sat down and read the whole case, as well as just the comments that were made by the panelists. So my thing is, it's the approach the court took in that they tried to strike a balance between freedom of expression and the right to access to court. I have a problem with that because I feel like those rights, they cannot be like competing rights that you can balance, because the rights to court, I feel personally, like right to properties, for instance, are elitist rights. Not everyone can access those rights. Not all South Africans can actually go and have the right to property and access that, or the right to access to court. You know, you need a certain amount of money to be able to actually access that right. So I thought it was really strange, or like, I understand that courts usually try to do this balancing process, but I feel like there was more care that was needed in distinguishing the two rights: the right to access to court, not everyone can access that, versus the right to freedom of expression. So yes, my thing was that the test, I really have problems with the way the courts balanced out those rights.
Thank you, Tina Bako. That's really interesting. I mean, maybe Courtney, you want to come in here. I mean, one thing that I noticed, maybe building on that question, is actually there's very limited rights analysis actually in this. I mean, it reads like a kind of common law type case. To me, it doesn't read like a constitutional case in that sense, and that troubles me in some ways. You presented very eloquently how those two rights are in conflict, but you know, they're very little rights analysis. So I don't know what your thoughts are on those issues. I maybe actually I'm going to ask Charné to come in if she wants to, because I know, Charné, you're about to get knocked off. So perhaps you want to come in on that question, or anything else you want to say in a conclusion.
Sure. I completely agree. When I considered this question, when I read through the panel discussion brief, I had the same thoughts around the balance between the Section 34 right and the right to freedom of expression. And it ties into what I mentioned earlier about the litigants bringing the SLAPP suits being substantially wealthy. And so is the question, I just don't feel like that's the balancing that needs to be done. They have the resources to exercise that right to court, whereas the people against which they're bringing the matters don't. And like I said, they tend to take advantage of that fact, of that disparity between them. That's all I wanted to add. And in case my battery dies, thank you so much for having me.
Thank you. Thanks for joining, and we'll have you as long as your battery lasts. I must say an assumption that's going through Tina Bako's question, and Charné, you back that up, is very troubling to me. The court shouldn't be there as a forum for simply people who can afford to get to court. Obviously, many of these organizations that are here are trying to enable people to get to court who are not wealthy, but it is true substantially in South Africa that people with resources generally can utilize courts, and those without. And I think that's troubling for our constitutional democracy, that we haven't sorted out access to courts more generally. But Courtney, I'd asked you a question more about that balancing exercise and the failure of the court really to engage so much on rights, etc., and to deal with this as a common law case in a way. What are your thoughts about that?
Yeah, so it's a really, really interesting question. And I would actually urge you to read the two cases next to one another, because I think the other judgment also gives a lot of context to some of the reasoning or some of the thought behind, well, what might influence the SLAPP, in the sense that I suppose on a converse, and this was very interestingly Justice Unterhalter's major concern, and you'll see it from his dissent in the Redell matter, regarding the general damages. And that is, you know, sort of the era that we live in, and the idea of sort of us being able to get behind our keyboard and say whatever we like in this sort of very technologically advanced society. And the fear is to remove too much recourse against a corporate entity that does, you cannot deny that a corporation certainly has a protectable interest in its reputation and its good name. And certainly damage would be done if a false statement was made from my Facebook keyboard that Sasol is poisoning our wells, for example. And so in an instance where you could raise a SLAPP defense to a defamation, let me say a legitimate defamation claim, and then the merits of the case are not considered at a preliminary stage, I mean, I think we can all agree that that has the potential to lead to disastrous effects in the other direction. And Justice Unterhalter raises this in his dissent regarding general damages, because there again, I mean, we're considering the interest of a corporate entity in that case. As to rights limitation, you raise an interesting point, because at no point in the SLAPP did we consider a rights limitation analysis. Because I suppose the question was very strictly and very narrowly, can the common law accommodate a SLAPP suit? I suppose if the argument was that a recognized SLAPP suit infringes the right to freedom of expression, that would have been a different kind of conversation entirely. But I don't want to be seen to be too biased or to defend the judgment, because I might be tainted by emotion in this matter. But it's fortunate and it's unfortunate, I think, how this matter came to the Constitutional Court, because as I say, it was on a very narrow point, right? It came on an appeal of the dismissal of an exception as to whether our law can or cannot sustain a defense. So the court could only do so much with that. And again, there was a reluctance at a stage to even develop the common law because of how technical this defense is. And Justice Majid in the judgment acknowledges courts are not primary lawmakers. That is Parliament. And I would certainly have been left with a certain level of discomfort if the court was developing the common law in a fashion that looked like a section in a statute, to say this is when the defense must be raised within 30 days of the filing, and then there's a reverse onus. I mean, the question goes from, is that developing the common law, or is that judicial legislating and sort of veering very far into the realm of Parliament? So I think it's a step.
Just a question there. Was there any, I mean, I know you can't say too much about what's going on, but couldn't the court have ordered Parliament to actually, wouldn't that have been a competent order, instead of venturing in that area, to say to Parliament, we think this is necessary given the nature of the rights concerned, you please within 18 months, as it's done before, legislate such a defense?
So it's so interesting that you ask that, because there was a judgment before. It's not a very interesting judgment, although I feel very strongly about it. It's the fidelity judgment, and it's about firearm control. I won't get into it. But basically, in that case, there's a lacuna in the Firearm Control Act. And there wasn't a frontal challenge to the act itself. It came in the form of the powers of SAPPs. So in that case, there was another fight amongst the judges where, in that context, where the judgment says there's a lacuna in the act, clearly this was a parliamentary oversight. So you still, at least there, you have a statute that is problematic, but there's a gap in it. The judges felt, again, that it would be entirely inappropriate, where there has not been a frontal challenge to the statute, to make any kind of direction towards Parliament. So Parliament wasn't a party. This was Fidelity versus, I think, the Minister of Safety and SAPPs. So it's the same here, where is it appropriate within the scope of sort of separation of powers and powers of courts where there is no statute? Would it be a competent order where we say, ideally, this is something that Parliament should deal with? Absolutely. But can the court go that far? I don't think so.
Okay, it's an interesting question. Actually, courts in places like India have done that. So South Africa has a very restrictive view of what can and can't be done, and Colombia. So, but yes, it's an interesting question there. I think let's bring in Lerato. Perhaps you want to. There's another question by Jamela. With respect to legislative development, is an amendment or expanded definition within the Vexatious Proceedings Act possible or consideration? Or Sithuthukile, I see you've just put on your camera if you want to deal with that as well. And I see Lerato, you also have. So does someone want to take that question about vexatious proceedings? Perhaps Sithuthukile, because I have a question for Lerato actually that I wanted to ask her about, this question of focusing on public interest litigation. So, Sithuthukile, do you think it would have worked to expand the definition in the Vexatious Proceedings Act?
I personally don't think so. When I read that act, it's like a 3-page act and it's a 1956 act. I found it hard to understand that specific provision that dealt with vexatious proceedings. I think it's 2.1 or something. And so I say that for 2 reasons. One, because I think the court, this wasn't the case. So yeah, it was clear, and the court made it clear, thankfully, that this wasn't a vexatious proceedings act type of case. The plaintiffs actually did try, or the applicants in the Concord did try, applicants, they did try and sort of try and knock the respondents off by saying that they should have relied or used the act. But it was clear that, and I think it was clear even from the High Court, that this wasn't the case for that, because it wasn't vexatious proceedings. I think what, as again, I'm going to say what Kel's view or position, that we need something separate that deals with SLAPP suits, because it's a special and separate animal to deal with, if I may call it that. And so I don't really think, I don't know what Lerato's view is or others' view, but I don't really think that it could have worked, because 1, it wasn't the case, and 2, that act is just problematic in itself. So I think amending it would even be worse. Fresh legislation that sort of deals with SLAPP suits and goes into the details of SLAPP suits, I think, is sort of the more suitable approach.
Okay, thank you, Sithuthukile. I think one of the arguments of the judges was that often there had to be some kind of a pattern of litigation of some kind, and that a SLAPP suit could happen in only one case, for example. And so there would be a kind of difference between the 2 different kind of categories in some way. Lerato, I was wondering, and it builds on Sithuthukile's point about it, something special about, and you made this point that in a way, one of your submissions was this should not apply necessarily in the case of an individual, but should apply more in the case of organizations that are challenging or, or in the relating to public interest litigation. And I wanted to challenge you on that. Like, what happens if I'm an individual and I, for instance, am challenging a major corporation? I'm take an example based on fact. Tiger Brands was accused by the NSPCA a while ago, of cruelty in the slaughter of pigs, in that the pigs were actually suffocating to death through the gas that was used to stun them. And that's an organization. But let's say I'm an individual and I am maybe even a worker there, that's maybe whistleblower, but let's say I find out about this. I'm an individual, I'm not part of any campaign, but I want to expose what's happening at Tiger Brands. And Tiger Brands immediately sends me a letter saying, I'm going to sue you for defamation if you don't, and I have very little money. And basically, why should it only be organizations and not individuals who are protected by something like this, this kind of action?
Thanks, David. I think the first thing to recognize is that the defense is not precluded to individuals. And if that's what was understood to be saying, I think we need to correct that certainly. What is important by what I was saying is that the defense is a defense you rely on when you have been acting in the public interest. And even in the example that you're giving, it can simply be argued that that person felt that it was in the public interest for that information to be made public, and so that people know how to act, and so that people are protected. And like I said, the example I gave was it wouldn't be an appropriate defense to be able to rely on in a domestic dispute, for example, where the one is slandering their spouse and the other spouse says one thing or another, and the one is trying to gag another, and then they want to claim that it's a SLAPP suit. it goes to the heart of the nature of the defense. And it also even goes to the fact that how it's explained is that it is strategic litigation against public participation. The minute it's individualized and it's between two individuals who are on the same footing, I want to say, then it's no longer about the public at all. And then in those instances, you have a myriad of other legal remedies, in fact, that are available to you. And we should remember that inherently the courts can protect their own processes. And Vexatious Proceedings Act is one of those processes that are there. And an individual could easily rely on that. And obviously the difficulty in a SLAPP, if you were to be limited to that as a solution, is that you'd have to bring a separate application. This could obviously be an interlocutory application, but it's certainly not within the same proceedings as we envisage, because then it wouldn't be as speedily and as a valid defense to the actual case. So how a SLAPP suit defense would work in an ideal world, which we are all advocating for here, is that, oh my goodness, apparently I forgot to put my phone on silent. Sorry. How that would then work in the ideal world is that the minute somebody brings this claim, you have this preliminary defense that should cut out the long process, that again, you avoid, you know, the use of money being extended, postponements on postponements, legal teams on legal teams, picking and nitpicking at everything. Even this case may be said to be a good example of what happens when one is typically engaged in a SLAPP, whereby, you know, activists are continuously going back to court to fight what some people may consider little things. Obviously, procedurally, as practitioners, we may see the importance of dealing with those nuances, but individuals and activists and people on the ground who normally don't have the resources might not want to be taken from pillar to post in this manner in order just to decide on procedural issues before even the nitty-gritties of the matter are attended to. So to answer your question, really, an individual is not precluded from relying on a SLAPP suit defense, but you can't just do it because you don't like your boyfriend or your girlfriend or your neighbor for that matter. That's not how it works. For that, there's several other legal remedies that already exist in our law that you should be able to rely on. And I think primarily that's why CAS thought this should be either a separate defense, and if we can't make it a separate defense from abuse of court process, because it is a form of abuse of court process, then the test should at the very least be distinguished to separate the issues and the kind of people who can rely on a SLAPP suit defense.
Right. No, so I think your argument is very good at that. This public interest element is really critical. I'm not sure I agree with you, and I don't know. I said we would need to tee this out, so maybe you can come back because I want to take someone's question. But I think you seem to suggest there need to be an asymmetry of power between, let's say, a corporation and an individual. What happens if an individual exposes, for example, terrible environmental pollution or cruelty or something like that of another individual? Would that still not be a case where SLAPP suit could apply because it's in the public interest? So the question is, does the actual identity of the litigants matter in some way? But I'm going to hold that question because I don't want to be the one only speaking. I see we've got a question. Tulani, I'm going to ask you to actually ask your question because it's not. There's a lot of background in what you said in the chat. But first, Heno, I don't know if your name is Henokash Agray. Please, you ask your question. Your hand is up.
First of all, thank you so much for this interesting discussion. The question I have is a bit general and not specifically related to the case being discussed. I just want to hear your thoughts, which is that SLAPP suits are lawsuit instituted by powerful person or organization against people who speak on public policy issue, and the aim is to silence criticism. So in this case, filer or plaintiff could be powerful individual like government officials. Having said that, I want to see the issue from the perspective of non-democratic states. For instance, is there a way for this suit to be included? Is there any way for criminal suits instituted by a public prosecutor to be included in a SLAPP definition? Because there are cases where public prosecutor initiates action not with the intention of ultimately bringing the defendants to justice, but rather to make them tired through the criminal procedure. There are a lot of bail, a lot of arrest, a lot of mechanism employed by government. For instance, in Ethiopian context, there are cases where these human rights activists are arrested and they are appointed again and again for bail and so on. So is there any way for this kind of suit to be categorized as SLAPP? Thank you so much.
That's a great question. I think it was dealt with to some extent in the judgment, and there's a discussion on criminal misuse of criminal law in this context, and it is a very serious problem, and it becoming a problem in South Africa too because of corruption, etc. So I'm going to ask someone to volunteer to deal with that. Let's take Tulani's question. Tulani, do you want to express your question as well? And then we can have volunteers from our panelists to deal with that. Go ahead.
Thank you, Prof. I've got a bit of rain where I am, so hopefully you can hear me. So I've just briefly looked at the case, and I really want to say it's a very technical space. So I'm just really throwing a bit of something from my initial thoughts about hearing the entire conversation. So my thinking is regards to the fact that most of these cases, they look like they're playing around defamation cases. So a big rich company will see a reporter sitting somewhere or the activists, and they really more or less use the specific protection from defamation. So if that's the case, in terms of the balancing that takes place, are there any lessons to be learned with regards to, say, how public officials are dealt with? And in a sense, if it's a president, there's an expectation that you should take a little bit more criticism. So perhaps we can even develop a case where some industries, say, for example, in mining, there's a history of people being abused in mining. There's a specific interest in us knowing these types of things. So perhaps what sort of lessons can we take with, how our politicians or other public officials are necessarily also dealt with when it comes to specifically the use of defamation? I think that's where my thoughts are really, playing around. And hopefully it makes some sense a little bit.
Thanks, Tulani. I think you're asking about, obviously many of these cases are defamation suits, and there's always an inherent balancing over there, and this sort of perhaps shifts some of the balancing, and you're asking about questions of public officials in that context. So perhaps on the first question of criminalization, does someone want to volunteer to address that? Yeah, Lerato, okay.
Yeah, so I definitely can say in other jurisdictions, and they definitely speak a lot more on malicious prosecutions. But then again, I want to remind us that in this particular matter, the court was really limited on what it can actually decide on, and the extent at which it could make development to the common law, if even at all. And really, I think we've already touched on what the question was, but I think it's really important to press on the fact that the court really was there to determine whether SLAPP suits are part of our common law abuse of process, and that if they were part of it, is ulterior motive something to consider? And if ulterior motive alone can be the deciding factor, and whether merits should be considered. I think the difficulty for us, because we only at this stage have developed the law to this extent, we haven't even really necessarily gotten into the realm of how the defense would work in a criminal litigation, for example, where in these malicious prosecutions, unless we are extending it to the next phase wherein there was unlawful arrest, and then you're now coming to say, well, there was malicious prosecution, and now I want to sue the state. But that also would look very different because we do not have the backing of the legislation as yet. If we were to lobby, for example, this would definitely be one of the things that Parliament would really have to carefully consider, because 100% SLAPP suits do not just come as a defamation claim. They even come as a form of an interdict. Sometimes somebody goes to court and seeks an interdict and purely to gag you, and then they will go and say, and this, David, maybe goes back to what you were mentioning when you were speaking about individuals. What sometimes happens is those individuals, despite the power disparities, will then decide to go to court that we're going to gag so-and-so. David has, hit the nail on the head, and they're discussing something we don't really want to be made public, and we don't like how it sounds. So now we're approaching a court of law and we're saying, we will interdict you from making any further defamatory statements. That's normally how those goes. But even in those instances, what we now have is a position where a SLAPP suit can even be a defense under those circumstances. The difficulty, again, is that we are still at a baby stage here. We've only just accepted this is a defense in our law. What it looks like, how far it goes, how you apply it, how quickly you apply it, those are still very open-ended questions. We hope our courts, as we go forward and as more people raise the defense, most of these answers will be questioned, because that's all we have.
Fantastic, Lerato, thank you. And I see Sithutukile's hand up. Sithuthukile, go ahead.
Thank you, Prof. Just to add,
just to remind me to come and tell you about a particular interesting matter that we actually did raise the defense in a protest where protesters were being interdicted, and this was a Carl's case as well. And we raised a SLAPP suit defense to prevent the applicants at the time from interdicting a protest action by a mining community.
Interesting. Well, we look forward to hearing that. We're nearly drawing to an end, so I'm going to ask everyone to have a short contribution. Sithuthukile, I'm going to give you each a chance to make a final contribution. Sithuthukile, you want to come in on one of the questions and perhaps to just summarize where you think things need to head next as well. Over to you.
Thank you, Prof. So just briefly, I'm adding on the question about the criminal cases. Just to mention, the court did deal with it briefly, though, and I think it dealt with it in the context of the ulterior purpose or motive requirements that the applicants were relying on so heavily. The respondents, that they were relying on so heavily. And I think obviously the court looked at the cases where ulterior motive sort of was raised in criminal cases, in criminal cases, and it concluded that it's just not going to work because these cases are different to what we have at hand. But I think another thing on my side, another difficulty would come from the fact that from what we have now, the test that we have, or the kind of test that we have now, the inquiry that we have, the two-stage part inquiry, if I may call it that, ulterior motive and merits, it probably won't really work, at least based on this test, because of the merits inquiry. So it won't work without one having to go through the entire trial to show if there is actually, if the arrest was in effect unlawful or lawful. I don't know if I'm making sense, but I think my view is that it probably won't really work from what we have now. I think, as Lerato was saying, we're still at the beginning. And I guess for me, the sort of the strong takeaway point for me is that we really do need at this point more clarity. We have some clarity from the court, but we need more clarity so that we can have more protection for activists and for people that are slapped in South Africa. And yeah, obviously we can only get that from Parliament. How long it will take Parliament, we all know how Parliament's processes are very long, but I think if the process is initiated, they can, I think that's sort of some progress as opposed to there being nothing. I'll end off there.
Thank you. That's a great point to end off with. I'm going to give you each a minute just to make a closing comment relating to where things are headed and also anything you wanted to respond to. So Courtney and then Lerato. Courtney.
Thanks, Prof. I'll be very quick. I was just thinking about the debate you were having with Lerato regarding the parties and a SLAPP. And as you were saying with the sort of counterfactual, what's interesting here is only the activists were sued. But I mean, as I mentioned, one of the defamatory incidents occurred on an SABC TV show. So what would the case be if, for example, Mail and Guardian was sued or the Star newspaper? Because there isn't that sort of power imbalance at all, if it's a sort of well-funded private journalist institution. So I think the key question is obviously the public participation aspect in that sense. So it seems like there's a few questions unanswered, and that's sort of this criminal aspect, although I think there is sufficient safeguards within the sort of malicious prosecution common law remedy that was considered by the court. But then there's also this issue of private bodies versus corporate entities and what's the requirement there. So, and as we said, sort of what the technicalities of how this defense works in practice. So yeah, I think it was a big step forward, but unfortunately, as I said, I think the court could only go so far. But yeah, there's still a lot to be done.
Common message, I think, thank you, not enough. And we don't yet have much clarity on certain aspects and how it will work. Lerato, your final comments.
Yeah, I look forward to seeing the judgment being put to action so that we can actually begin to put in, you know, those, we can dot those I's and T's, which are clearly obviously missing. And like I said, as more people approach courts of law and they start exploring how this defense might work, the more clarity we'll all have. Again, I definitely want to emphasize that at this stage, the defense, if you can show that you acted in the public interest, seemingly is applicable to you. Like I said, it's not limited to defamation. It works in interdicts, as we have learned from Pulse, that you can actually use a SLAPP defense to fight off an interdict. And there's probably a lot more that can be done, as long as you can show that you're acting in the public interest and that the other party is actually just looking to silence you and is acting with an ulterior purpose. And I suppose we will find our way. But I think we took a very big first step, a necessary step for our jurisprudence and for the interest of our legal justice system.
Absolutely. Thank you very much to all our panelists. A fantastic discussion, to Courtney Jones, Sithuthukile Mkhize, to Lerato, Pasha, and Charné, Tracey. Really enlightening. This is a very progressive development. I think everyone agrees that it's an important development, though there are many areas of unclarity. There's a need for the legislature to step in. And I think it does seem to me that there's going to be a need either for further judicial development or for a campaign to push the legislature, because I haven't heard any discussions that they're actually taking on board this particular challenge that has been said to them by the court. So I'm hoping that it will assist parties. It is very vital for the defense of public interest areas, but it's a really good progressive step. Thank you to everyone who's attended. As I say, we look forward to seeing at our next seminar, which will be on the 28th of March. And with that, thank you, everyone, and you're welcome to share it. I know there are many NGO people here. It will be on our Facebook page, so you're welcome to share the discussion, and hopefully we'll continue the engagement on these important issues. Take care and good evening and cheers. Bye-bye.
Goodbye. Thank you, David.
Thank you.
Thank you. Bye.
Bye.